that trans ideology doesn't just damage their kids' health and bodies, it fractures family bonds and shatters relationships. These affected parents are suffering an otherworldly anguish they never knew existed. And in the spirit of being action-oriented, which we're exploring in this season of Generation Indoctrination, in this installment we'll speak to those who are helping families recover from what many describe as the worst nightmare of their lives. But what can be done for parents who are on the front end of this struggle, before their children are targeted and become mired in this contagion, and an alternative gender identity is concretized in their minds? And given how much of this occurs in school settings, often behind the backs of parents, can parental rights be legally protected? I often ponder the plight of parents like Tammy, a feisty Midwestern mom with an unmistakably Wisconsin accent who was featured in the postscript of the documentary Dead Name. That mom was at the center of a legal effort alongside other parents in the Badger State. School officials there were socially transitioning her troubled daughter behind her back and undermining her parental authority. This was their official school policy, they told her, but she wasn't buying it. Tammy's attorney, Luke Berg, is the deputy counsel of the Wisconsin Institute for Law and Liberty. Last year, he scored a major win in court on behalf of parents. The Kettle Moraine case, as it's called, is being cited around the country in other related matters. The judge ruled that the parents had a fundamental liberty interest in the decisions regarding care, custody, and control of their children, and that school districts cannot supplant a parent's right to control the health care and medical decisions for their children. And they agreed that social transitioning is a powerful psychotherapeutic intervention, which should usually be preceded by a mental health professional, conducting a psychological assessment in order to see the benefits and challenges of such a transition. Thus, whether to address a child as the opposite sex is indisputably a medical and healthcare issue, the court said. And Berg told me that this was an issue that many parents became interested in when they saw what was allowed to happen in schools without their knowledge or consent.
I started working on this, researching it, and just thought this is a pretty clear violation of parental rights, and it's pretty stunning as well. And so we put together a group of parents to challenge the policy. I think we had either 14 or 16. It was a lot of parents. And we filed a lawsuit in Wisconsin state court challenging that policy, the Madison School District, as a violation of parental rights. And that was the first case in the country to challenge one of these policies. So sort of a groundbreaking case. So that case got a lot of media attention. People were interested. I think a lot of parents weren't aware that school districts were passing these policies. But after we initiated that lawsuit and it got some of the press that it did, we just started getting calls from parents constantly on this issue. I mean, parents saying, yeah, I found this in my school district, or this happened to my child. And so about, I want to say a year later, we got a call from our clients in the Kettle Moraine case. It was a mom who said, I'm dealing with this personally. My daughter went through this issue. She was struggling with anxiety and depression. It spiraled into questioning her gender identity to the point where she wanted to change her name and pronouns at school. And we, after researching it, came across your case and your discussion of the issue and decided this wasn't what was best for our daughter. And we told the school that we didn't think that was best for her, and we wanted them to use her female name and pronouns while she was at school. And the school basically said, sorry, too bad. If you continue sending her here, we're going to respect whatever she wants in terms of names and pronouns. It doesn't matter what you parents think is best for her. And so at that point, she reached out to us, and it went from there.
So Luke, what else happened as Tammy and other parents kept fighting the school? And how did you ultimately decide to take the action that you did in the courts? Did you face any legal complexities that made this a thorny, complicated endeavor?
We didn't get involved immediately, but mom, based on what the school district said, pulled her daughter from school and immediately started looking for a school that would respect their parental rights and respect their decision. Pulled her daughter from a mental health facility that had immediately rushed to affirm that she was really a boy, and that told her the sooner she transitioned, the better, and that her mom would be her worst enemy. So her mom pulled her from that environment as well, pulled her from social media. And within about 3 weeks of being removed from all those environments, her daughter changed her mind and realized, you were right, Mom, this isn't actually who I am. I was confused, and all these adults around me telling me I was really a boy confused me further. And now she's very happy and well adjusted as a girl. So we had been talking to the parents sort of throughout this process. And after it seemed like the sort of situation had stabilized, we decided, you know what, we should represent them and do something about it to change this. And everybody who's a parent knows that, you don't say yes to everything your child asks for. So we wrote a letter to the district and said, you know, what we want you to do is admit this was a mistake and change the policy. And the district refused to do that. So we ended up filing a lawsuit and we won. It was a really big win. It was the first case to win on the merits on this topic. Proud of that and excited about that. And after we won, sort of in the meantime, while the case had been litigated, the school district board switched to conservative leaning. You know, this happened with a lot of school boards across the country during COVID. And as people started to wake up to these types of policies, I think that really got people invested in their school districts and running for school board. And so this school board flipped during that time. And so after we won in the trial court, the school district decided not to appeal and ultimately changed their policy, which was the goal. So we see that as a huge win and are really excited about what happened in the case.
As awareness grew about what the schools were doing, even parents whose kids were not identifying as transgender decided that the policy that had been enshrined was an erosion of their rights, and therefore was something worth resisting. They were concerned enough that they banded together to set a challenge in motion.
None of the parents had children who, as far as they knew, were dealing with gender dysphoria at the time, but they all had children in the school district and felt that they were directly affected by the policy because the policy says if your child deals with a struggle with their gender identity, the school won't tell you and will keep it a secret from you. And teachers are actually prohibited from telling parents about what's happening at school. I sort of like to say that they're treating school as if it's Las Vegas, right? What happens at school stays at school. Everybody who's there knows what's happening, but the parents don't get to know. And the policy even went so far to say, teachers, you might need to use one name during the school day. And when the parents show up or in communications with parents, switch back to using the other name so the parents can't figure out what's happening during the school day. So, you know, it was a preemptive lawsuit, but I think we had a pretty strong argument that if your whole policy is to hide things from us as parents, we have to sue preemptively because we don't know what we don't know and we don't know what you might be hiding from us. And so that was sort of the basis for their standing, was just to say, we need to make sure that if this issue arises for our child, and nobody knows the future, nobody knows what their children may or may not deal with in the future, we want to ensure that the school district is going to defer to us about whether a transition is in our child's best interest. So there's probably 30 of these cases across the country now challenging these policies. In a number of them, it's clients like our Kettle Moraine clients who weren't thinking about this issue, but then they had a child who went through it, and a school district that hid the issue from them or disregarded their decision. And that kind of awakens these parents and makes them angry, as I think it would any parent, and makes them plaintiffs in cases. But there's also a lot of cases where parents are suing preemptively. And I think there's a good argument that they should have standing to be able to sue preemptively. Now the cases are going both ways, and some cases are getting dismissed on standing. If the parents can't say that they have a child who's currently dealing with gender dysphoria, other cases, and it's still early in the stages of the litigation, so it's going to take a while before all this shakes out. But I at least think there's a very persuasive and powerful argument to be made that if your policy is going to openly state that school will hide things from you, you should be able to sue in advance to ensure that if it happens to your child, you will be included and deferred to.
Even with the encouraging legal win that's now being cited across the nation against school systems overstepping their authority, the battle forges on.